Welcome to the M&A Unplugged podcast. Our mission is to help you be better prepared for your business acquisition or sale. Being prepared will ensure you maximize returns and minimize risks. This is M&A Unplugged with your host, Domenic Rinaldi.
Welcome back to M&A Unplugged. I'm your host, Domenic Rinaldi. As a business buyer, you might think that running a comprehensive diligence process, identifying all the risks, structuring an asset versus a stock transaction, and negotiating solid reps, warranties, and indemnifications is enough to keep you protected from future liabilities. Unfortunately, that may not be the case. Successor liability is a legal term worth discussing with both your M&A advisor and attorney as it relates to a contemplated transaction. In a nutshell, a successor liability is a liability that may follow you as the buyer of the company from issues related to the seller's operation of that entity. Protecting yourself from any successor liabilities should be of paramount importance. Today, we are being joined by my good friend and bankruptcy restructuring attorney, Dino Armiros, from the law firm Saul Ewing Arnstein Lehr. Dino discusses the overview of successor liability, how those risks can be manifested, and how best to mitigate these potential liabilities. Dino brings a unique perspective to this topic, having the experience of both helping companies undo the damage of these liabilities, as well as being involved in the initial M&A transaction. I know you will gain a ton of knowledge from Dino's expertise in this area. Before we get to today's episode, if you want to avoid the common deal pitfalls and the risk of losing substantial dollars, you need to know how ready you really are to buy a business. Because I believe proper preparation is so critical to your deal success, we have published a catalog of free resources to help you be better prepared. You can access these resources on our website at k2advisor.com, K2adviser.com. Being prepared is critical to ensuring that you maximize returns and minimize risks. Thank you for being here and hope you enjoyed today's show. Dino, welcome to M&A Unplugged.
Great to be here. Thank you, Domenic, for the chance to talk to you and your audience. I'm really excited about it.
Yeah, not only are you a good friend, but you're a hell of an attorney. And I'm excited to get into this topic today because I don't think it really gets enough conversation in M&A transactions. A lot of people tend to talk about reps and warranties and indemnifications, but the topic that we're going to be talking about today, successor liabilities, really so critical. And you see that a lot on the back end with your bankruptcy and workout work. But boy, if you could do a little bit of preventative maintenance during the M&A transaction, you've really set yourself up for success. So why don't we start off with a quick bio on yourself, and then I want to get into what is the definition of successor liability?
Sure. Absolutely. Well, so I've been practicing law for about 40 years, and I spent the earlier part of my career in litigation, but a while ago I shifted more into distress, which is workouts, up to bankruptcy, restructuring transactions, sometimes in court, sometimes out of court. Very challenging area, and it's a situation where if something can go wrong, it will go wrong. Mm-hmm. So you get prepared for all sorts of different eventualities, especially since the client in distress, or if you're representing the lender, the counterparty that's in distress, there's a lot of desperation going on. So it was a very good training ground. About 10 years ago, I started shifting more and more into traditional transactional work. And so I've been doing a mix of distress transactions and also healthy transactions, and most recently, mostly healthy transactions. So like I said, that's kind of a good training ground, and that creates the sensitivity to the potential successor liability, which we're going to be talking about here, because if you're dealing in a situation where a client is in trouble, the buyer does not want to buy those troubles. And frequently, I mean, most commonly in healthy transactions, it's not that big of an issue because it's a healthy seller, healthy buyer. There's positive stuff going on. There might be some excluded liabilities, but in general, what I like to joke about is that the difference between a healthy transaction and a distressed transaction is at the end of the healthy transaction, there might be a post-closing party and everybody's celebrating. At the end of a distressed transaction, a lot of times people are just kind of happy that it's over with and we dodged some bullets and we're moving on.
Yeah. Quickly exit stage left and
exactly
put it in the record. Well, I got to imagine your experience in bankruptcy and workout really lends itself very well to the healthy transaction M&A side because you see what could go wrong and you have a leg up on how to prevent it. So with that said, let's get into what is the definition of successor liability and why should buyers and sellers really be aware of this and corral all of their efforts around understanding if there is one there.
Sure. So successor liability is a concept where the successor, i.e. the buyer in an M&A transaction, is saddled with the problems of the seller. Now, again, in a healthy transaction, there's been due diligence. They've scrubbed the company. They know what the problems are typically. And also, most importantly, there is enough money in the transaction so that there's no claim that the creditors were shortchanged in some way. And so generally, successor liability is something that's not really a concern in the new company because they've bought, they've assumed liabilities. They know what's going on, and there's a great deal of comfort now. And then you also have the standard safeguards in the forms of perhaps R&W insurance, or you just have an indemnity structure that's been set up, perhaps a holdback. So that aspect of successor liability has been successfully managed in so many words.
Yeah, and R&W insurance, just for the listeners, is reps and warranties insurance. We actually have another episode that was dropped with Patrick Stroh that talks about reps and warranties insurance. So if you want to reference that podcast, you can learn more about that. But you're right. I mean, there are things you can do to make sure that you're protected. But even in a healthy transaction, though, Dino, there's the potential for some successor liability to rear its ugly head, right? Like for taxes, right? If proper tax lien searches weren't done or something was missed, that potentially could roll over to the buyer, correct?
Right. And so there's that kind of, sort of a black swan event type of thing that could be a problem that might emerge during due diligence. So you could say, oh my goodness, well, I just discovered the fact that you have a real contractual dispute with one of your vendors or with one of your customers. And maybe it emerges during the midst of the transaction. And you could have a 7-figure exposure, and do you want to kill the deal, or do you want to somehow structure the deal to accommodate that potential risk? Yeah. And from the buyer's perspective, they want to make sure that it's once and done. In other words, what you've done in terms of that structuring has kind of put that problem in a box, and it doesn't come back to haunt them. And the coming back to haunt them is successor liability. Right. And so that would be the type of situation that would come up. It could be, let's say, a workplace situation. All of a sudden you discover that your warehouse in Topeka is rife with all sorts of personnel problems, and maybe an episode is going on over there that you just, oh my goodness, you just discovered it. And the company is otherwise healthy and it's successful, it's profitable. You want to sell it, but on the other hand, the buyer is saying, you know what, you got to deal with this problem, and I don't want I don't want you to make it my problem.
Right. So, Dino, we just ticked off 2 potential successor liabilities with tax and personnel issues. What are the most common sorts of successor liabilities that people need to be aware of?
Well, I think that probably the Well, there, kind of like every situation is different.
Yeah.
So, but I would see something like potential tort liability. There might be insurance to accommodate that, but there might not. And so that is that's one sort of like amorphous problem that could be out there. Another thing, and I think that it's fair to say that this is something that would be coming out in the context of due diligence, and that would be a contractual problem. Where you say, okay, I have, we have a supply chain issue here, and all of a sudden, this thing is starting to go sideways, and how do we manage this? Or there's a disgruntled customer, and they've been threatening the lawsuit. We thought we had it settled, and all of a sudden it explodes, and how are we going to deal with that?
Yeah.
So those are the kinds of, it's the kind of stuff that's sort of lurking out there, and it crops up.
I even read an article recently that defective products, to the extent that there were defective products and those issues haven't been addressed, you as a buyer, if you continue those practices of manufacturing and distributing defective products, you potentially are liable not only for what you're doing today, but for what the seller had done while they were running the company, correct?
Right. So exactly. So like I say, so that would be a tort. That would be something that would be, that could create personal injury or personal harm. And so clearly the buyer then really has to understand what that problem is. Now, if the process itself, it creates the defect, and they continue that process, they're sort of exposing themselves to the successor liability issue because they haven't sort of remedied it. Maybe they discover it 6 months after they buy the company, and they say, oh my goodness, we've got to stop this. We've got to use a different chemical, or we've got to use a different technique here for building this, for manufacturing this product. Therefore, we've kind of stopped it. And the problems that had been created in the old company stay in the old company. But the first point of departure in terms of protecting yourself on successor liability is the consideration of going between an asset sale and an entity sale. In other words, if you're selling stock or if you're selling LLC interests versus selling the assets that are held in that entity. Now, I'm going to do a disclaimer right here, and I'll probably do it again later in the discussion. We're not giving legal advice here, yeah. and we're just talking hypothetically about situations. Mm-hmm. So if someone says, "Oh my goodness, I have a defect problem I got to deal with," well, Dino said this on the podcast. You can't rely on this because every situation is fact specific, and you have to really engage your own counsel. But what we're talking about is, in generalities, in broad strokes, what kinds of considerations you have to flag. Yeah. So one point of departure is the idea of the entity sale versus the asset sale. If you are selling the entity, if you are buying the stock of a company, then you are buying its problems. Yeah. If you've done your due diligence and you're satisfied with the company, then that's fine, and then you feel comfortable. But if the aggrieved party is going to sue company XYZ, and you buy company XYZ, then you'll be the defendant. Yeah. Yeah. So you can allow for this is a liability that's being excluded, but by buying the entity, you are creating a through line of exposure to yourself.
Yeah, so I think the point that you're really making here is that the better defense is buy the assets, form your own entity, pull the company's assets into your new entity, but that is not the holy grail. That doesn't necessarily create a complete Chinese wall. It's a great start, right? But it's not exactly where it ends, right? The story can continue.
Right.
And I even read.
So there's an adage that.
Go ahead, Dino. Sorry, go ahead.
Yeah, no. There's an adage that that the debts follow the assets,
Yeah.
and you have to kind of separate them out because you can't just strip the company of its assets and say, "Oops, you've got your problems over there," but you also have an empty shell of a company.
Yeah.
You have to allow for those problems in the old company.
Right. I even and this is always dangerous, right? You read things and you go on the internet, but I did actually get a hold of some case law, and I was really interested to see one of the exceptions that popped up was something that they called continuity of enterprise. So even in a scenario where you take most of the employees and all the products and services, if there's a continuity of enterprise, that potentially is something that the courts would look at and say, hey, you are a successor. These liabilities can transfer even in an asset transaction. It sounds far-reaching to me because in my experience, most deals you're transferring all the employees, you're transferring all of the products and services. So that seemed a bit far-reaching from my perspective.
Well, keep in mind that issue manifests itself when there's nothing in the old company. So that the party that's asserting the claim, whether it's in a lawsuit or a lien or something like that, has already found that the old company is an empty shell. And they're saying, okay, well, who's my target now? And they say, okay, well, here, you are continuing to run the business. You didn't leave sufficient capital in the old company to deal with this problem. So therefore, you're basically an alter ego. You are a successor to the problems that you thought you left behind in the old company.
Yeah.
And the continuity of enterprise is one of the elements. So there are others. For example, if you have the same leadership personnel, if you have if you're operating essentially from the same premises, so you've kind of switched hats, kind of. So that's in a situation where you're trying to kind of evade some of those old problems, but you're not really doing it effectively.
Yeah.
If it's an arm's length transaction, and there has been a bona fide payment for the assets that are bought, then you are starting to create that firewall between the old company and the new company. And most healthy transactions are done in that manner. Right. They're arm's length. There might be a rollover of 20% or 10%. You might keep the old management on for consulting purposes or as employees, but there are new owners, and the new owners are different from the old owners, and not just son-in-law.
Even if the previous owners retained 10 or 20% of the new co, you can create a scenario that you've created that enough of a firewall.
Correct.
Potentially.
And potentially, right. I mean, it's kind of, like I say, everything's very fact specific, right. And especially in this continuity and the successor liability piece, there are many facts that go back and forth, and you have to analyze all of those facts. Yeah. But getting back to some of the basic preventatives, the idea is that if you won't be facing that problem as a successor if you have properly allowed for that liability in the old company.
Yes.
And so
let's talk about that. Give some examples. What do you mean by that specifically? If you've allowed for that in the old company?
Well, so keep in mind when you buy the assets, the check is made payable to the company, not to the individual owner. Right? So let's just say it's a $10 million transaction. The company has $10 million, and there's been some liabilities that have been left behind, including that product defect situation, including that potential hostile workplace situation that's going on at that warehouse, including the potential of tax liens that you weren't aware of. You became aware of during the due diligence period. And you say, okay, well, what is that problem? Because if the owner of the old company says, oops, hey, I got a check for $10 million, thank you very much, and they take the whole money, they take all that out, well, you've left the old company impoverished.
Yes.
And you have not treated your potential creditors properly. So you want to create a structure whether it's with insurance, whether it's with a holdback escrow, whether it's with a personal indemnity, whether it's some manner, but you have to say that you can't just sit there and shrug your shoulders and say, you know what, I know that we just discovered that there was a poisoning situation as a result of our products. And, you know, if the insurance isn't good enough, then so be it. Well, if the insurance isn't good enough, then they're going to start looking for other targets. And so you have to allow for that. So how do you determine what kind of pool to leave to do there? One thing would be to talk to a professional. And the professional could be someone who gives a solvency opinion, or someone who's an expert in the field and says that, you know what, in these kinds of situations, for example, in an injury situation, in Cook County, the jury verdicts have come in between X and Y. And we feel that that this is an appropriate amount to hold back. You know, it's not by any means definitive, but we've examined the situation and we've decided, we're giving our opinion. Now, the professional that gives that opinion is going to charge a fee. Mm-hmm. That fee is sort of like an insurance premium. But on the other hand, because it's pretty wide open, that you're not going to necessarily be able to sue that professional for malpractice if they're wrong. But it is an arrow in your quiver. Yeah. It is something that you can point to say, hey, look, you know what, I tried to do the right thing. I hired this reputable company that is expert in this area, or it's an investment bank that understands different types of, you know, has been exposed to a lot of these things, and they gave me an opinion. They said, you know, we have to hold back $5 million, and that's what I did. I left $5 million in the old company. Now, you know, 3 years later, after a lawsuit, I got hit for $7 million. Yeah. Well, the $5 million that we left behind was a good estimate of what it was at that time. And therefore, that protects you. Now, whether the other party wants to go after, they've gotten the blood in the turnip in the forms of the $5 million. Yeah. Maybe they go after the new company for the $2, but you've started to create a basis for saying this is going to be we properly reserved for it, and the new company should be off the hook.
Got it. So, Dino, in a scenario that you just described, you know, that might come as a shock to a seller, right? I mean, they might be looking at this going, wait a minute, I've got to leave half of the proceeds in an escrow account for future liabilities. How does a seller get some comfort around these things? What can a seller do to mitigate their liability so that they can walk away with the maximum proceeds in their pocket at the closing table?
Right. Well, so the idea is that you have to, you kind of have to balance everything, and you have to say, look, you know, in the $10 million sale, $5 billion reserve situation, at least I got the 5, and at some point I could possibly get the other 5, because you could wait for a statute of limitations. You could perhaps try to be proactive and say, look, this is the best we can do for you here. You know, we've got some money set aside. Maybe don't tell them you got the full 5, but say that we've got some money set aside. Let's settle this. Or you could just sit there and say, okay, we'll lie in wait and see where it goes. But in terms of bulletproofing, there's really no way to bulletproof situations like this.
Could tail insurance, and tail insurance being an insurance policy that an owner of a business would take out once they sell their business to a buyer, that remains inside of the old entity, right? To cover for certain liabilities.
Right. So typically insurance would cover tort.
Yeah.
And so if there's an injury situation, absolutely, then you say, okay, what is the premium? You know, what are we going to pay here? And the insurance companies they understand underwriting probably better than anybody. Right. So they can look at the situation and say, okay, I get it. You're going to have to pay a lump sum of this, and then we'll take care of everything else. So that's certainly an option. The question is
reps and warranties insurance potentially.
Well, in reps and warranties, that would be in a more conventional situation.
Yep, right.
If you are aware of a specific item, keep in mind the reps and warranties, one aspect of reps and warranties insurance is that they kind of do the underwriting that you have to disclose. So if you know about the situation, then either the premium goes up or they say, you know what, this is going to be carved out of the coverage.
Carved out, right.
So you have to be sensitive on that front. But like I say, if you can find an underwriter that's willing to that you can lay the risk off on, absolutely, because then that also becomes your defense to the aggrieved party, and you say, look, I did the right thing. I tried to allow for this potential exposure.
Yeah. So I think some key takeaways there for me are, one, in the transaction, when the final asset purchase agreements are getting drafted, you want to make sure that you're accommodating for all of these things in that asset purchase agreement, and also making sure that the owner is going to keep that entity open for some period of time, so they, like you said, don't bleed the business, and now it can't handle any known or unknown liabilities that might pop up 6 months or a year later.
Exactly. The idea, the concept behind the theory, the legal theory for going after the owner or the seller entity is that you have stripped the company of its assets. So arguably the transfer of the proceeds from the entity to the buyer is considered a fraudulent conveyance, because what you've done is you've left the old company with an inability to pay its debts, as either as they come due, or the potential exposure is greater than the potential than the assets that you've left in the company.
Yeah.
So you have to be prepared to defend the distribution that's made to the owner and say, look, we have properly allowed for this exposure, and therefore the transfer that was made to the owner does not leave zero in the company. Yeah.
Is that a difficult conversation for the buyer's attorney to have with the seller's attorney and then the parties? Because I'm sure all sellers want to take all their proceeds out, right, and go on their merry way, and they want to call it a day, right?
Well, so Domenic, that's where you earn your fee, because maybe the first conversation is with the intermediary, and you start saying, "Hey, we've got a problem here. Let's," because it's a business situation, and arguably, because what you're saying is that you might not be able to take as much money off the table as you were contemplating.
Right.
And then you could bring in the lawyers for the drafting, but you also might have to bring in other professionals for purposes of trying to assess the risk and trying to determine it.
Yeah, the level of difficulty with this type of conversation is that you're probably not having it during the letter of intent negotiation, unless there's something material that's known at that point in time. So this is a discussion that's happening after diligence or during diligence, which could materially change the outcome of the deal for the seller and maybe even the buyer, right? And so it's a renegotiation, and that's never a happy thing to do in a transaction.
Never a pleasant conversation, right? Yeah. So that would be it. Because the thing is, if you are going into the transaction knowing about it, then when you're putting together your book or your SIM, you could just say, "Hey, look, there is this situation here, and this is how we're contemplating dealing with it." Or you have to buy the company subject to this problem. It'll impact your purchase price, but you have to take over the problem because we don't want it.
I think this is an excellent point, Dino, that if there are material things or things that are on the fringe, it's so much better to get them out early and get them on the table early, so all the parties can contemplate it as you're getting an initial offer of interest or a letter of intent, and you don't have to maybe go through a painful renegotiation later on.
Exactly. It gets rolled into the structure of the transaction rather than, like you say, having to do a kind of a reassessment of how we're going to do the deal.
And even if you don't know, the totality of the issue, at least if you document it in the letter of intent and you identify that this could be an issue, we don't know what the total liability is, but at least we know we have to address it, then all parties are on notice up front, right?
Right. Yeah, that's it. So because the other part of it is that if the seller knew about it and really didn't talk to the buyer about it, then that creates some issues there.
Yeah.
And so typically I would think that something like this would come up. It's like an oh my moment.
Right.
What's going on.
Yeah. And then, and we're talking about the things that are known. And obviously the big challenge in all of this are the risks and the liabilities that are unknown that might happen after the sale, right. Which is, something that the parties need to consider and contemplate up front. And the buyers need to do their diligence. That's number one. And then put in all of the downside protections, reps and warranties insurance, tail insurance, right. Director's insurance, whatever they need to do so that they've got a firewall, because there will be unknowns probably.
Right. And then you're talking about a conventional transaction where you're trying to get your arms around the risk. You think you've probably covered everything with your due diligence. And but then you allow for potential perhaps a holdback to see how things play out over the next 12 to 18 to 24 months, and then you have your fundamental reps, which are obviously longer, but your specific reps that are transaction based, you hope that you've properly allowed for them, and then you have the negotiation with the basket and the cap, and where we go with all this, how do we manage this risk. And that is more of a standard negotiation that goes on in an M&A deal, rather than something that appears out of the blue.
Yeah. So Dino, this has been awesome, tremendous information. We're going to wrap it up here in a minute, but I want to reiterate what you said earlier around every situation is different.
Yes.
And that's why when you're contemplating a transaction, whether it's of a healthy company or a distressed company or a workout, you need an expert at your side. And certainly someone like you has the experience of both doing the workouts and restructurings and now the healthy company transactions, is tremendous expertise to have on your side. Dino, is there something we haven't covered at a high level or some high level points that you'd like to make as we wrap up here?
Well, the one thing I realized I didn't cover at the beginning was my law firm.
I covered it in the intro, so
okay, great.
Covered in the intro, but please go ahead.
Yeah, sure. Saul Ewing Arnstein Lehr. We're a mid-market firm. We've got lawyers in 16 cities throughout the United States. Our biggest office is here in Chicago, and then we also have prominent offices in Philadelphia, Baltimore, Miami, and other offices throughout the major markets in the starting from Minneapolis, going to Boston, as far south as Miami. No, I think that the big takeaway here is that there is, well, I'll tell you, years ago I read a book called "You Can Negotiate Anything," and to me it's one of my favorite business books. And I read it before I was even practicing law. And the concept is that if they're willing parties, they can figure out how to manage this risk, and hopefully with good advisors like you're talking about, you can successfully navigate these waters, and if people are forthright and are dealing in good faith and are willing to handle these transactions, you can overcome that. That's I think that's really something that's something it's something to keep in mind in going through a transaction.
Common themes in almost all of my podcasts: have good advisors, willing parties, and you can get deals done.
Exactly.
It's been such a pleasure. If folks wanted to reach you, how could they get in touch with you?
So you can go through to my through email, constantinos.armiros@saul.com, and we can provide that, and then or just call me. That's all. I'll give you my cell phone number, 847 847-226-6031, 847-226-6031.
Awesome.
So yeah, that's email and phone. That's really, that's where I am. As you can see, I'm working from home most of the time these days. Hope to get back downtown sometime soon. But yeah, we're
you're
here.
healthy, you're safe, you're doing deals, and that's good. That's good news.
Yes, exactly.
All right, Dino, thank you
My
so
pleasure,
much
Doug.
for being on. All of Dino's contact information will be in the show notes. Really appreciate you being here.
Thank you so much. Thank you, Dominic. Bye-bye.
I hope you enjoyed this episode. All of today's information will be available in the show notes. If you enjoy our content, please remember to subscribe and review our podcast. I look forward to seeing you again on the next episode of the M&A Unplugged podcast. And until then, please remember that scaling, acquiring, or selling a business takes time, preparation, and the proper knowledge.